Welcome back to KTN Prime. Now, earlier this evening, the International Criminal Court at The Hague terminated the case against Deputy President William Ruto and former radio journalist Joshua Arap Sang. Joining us in studio to just shed some more light on this ruling is Njenga Mwangi, advocate of the High Court, who's also licensed to practice at the ICC. Welcome to studio, sir. Thanks for joining us.
Thank you very much, Kitili.
Now, the ICC judges decided by a majority that the case against Ruto and Sang be terminated, adding that this does not preclude a future prosecution. What does this mean?
Well, first and foremost, it's that at the conclusion of the prosecution hearing, when it concluded its hearing, the defense counsel, both Mr. Sang and the deputy president, told the court that they want to bring in a motion of no case to answer, that the prosecutor has not established a prima facie case to warrant putting the accused person on their defense. The court, at the end of the day, by the majority, ruled that the prosecutor did not present sufficient evidence to warrant putting the accused person on their defense, and that the prosecutor failed to prove one very key element in any criminal prosecution at The Hague, that the existence of a network. Because the crimes could not be committed by an individual. He must have been doing it through a criminal enterprise, which is called a network.
Right.
So the court, by majority, decided that that element was not proved, and therefore there shouldn't be no case to answer.
Now, the third judge, Herrera Kabuchia, appended a dissenting opinion, believing that this case had the merits to lead to maybe a conviction. Does this take away from this ruling today?
No, it doesn't, because the court rules by majority. It's either by consensus or by majority rule. Of course, the prosecutor has the leeway to appeal against that decision. Although, strictly speaking, looking at the whole evidence as has been adduced, and the decision of the appeals chamber in the latest application, where it refused to allow recanted evidence or evidence that will not be subjected to cross-examination, I don't believe the prosecutor will appeal.
Right. Now, we have seen so many reactions tonight. People talking about justice for the two suspects, William Ruto and Joshua Arap Sang, following this ruling. What about the victims? Now, where do they turn to for justice?
Let me put it this way, that this court by itself and the prosecutor had a duty to the victims to manage their expectations. To manage their expectation begins from arresting or summoning the rightful person to be charged, doing thorough investigations and adducing that evidence in court. You cannot, the expectations, justice to the victims can never be served by convicting the wrong person. And that is why in the criminal justice jurisdiction, there is always the presumption of innocence until proven guilty. And even when you're convicted, the judge must be satisfied beyond reasonable doubt that the evidence connects the accused persons with the crimes committed. So as long as that threshold has not been met, I was very doubtful that they will ask the accused person to defend themselves.
You've mentioned that the chief prosecutor Fatih so they can appeal this. How can this be done, and what should the victims expect from this?
You know, again, that would be a tragedy if she appealed, because if she appealed and the appeal is again thrown out, that is again killing the expectations of the victims. The victim deserves justice, and the victims do know who the perpetrators of these crimes are. We know for sure is that there are quite a number of people who have been convicted, who've been charged in local courts and convicted. There are several who have been charged and acquitted because of lack of sufficient evidence. So the ball right now is in the court of the Director of Public Prosecution. Will he pursue criminal prosecutions of what we'll call the middle level and the low level perpetrators, or will he not? That again depends on the evidence that was gathered initially. Because if you want to do an investigation 7 years after the offenses were committed, one thing is that memories fail, evidence gets destroyed, I really don't know, but I've done my bit with victims, and quite a bit of them, literally speaking, wish this to go away. Today I was talking with some victims,
Right.
and what they told me is, if you manage to forgive the colonialists after the atrocities they committed, especially in the Mount Kenya area, it's about time we forgive our own who committed crimes against us and we move on. But on the same basis, I would urge the government to think of ways of compensating the victims, because the 35,000 that they were given was not sufficient, because somebody whose property is worth 10 million was destroyed, giving him 35, it's a mockery of justice.
It's a mockery of everything.
But if I remember the president, in the last but one State of the Nation, the government set aside 10 billion shillings to address historical injustices. And the victims of the post-election violence are part of the injustices that happened in this country.
Now, this journey, or this case, yes, these cases began on the 15th of December.
No, on 10th. The actual case began on 10th of September 2010.
Right. So it has been 5 years, and yes, the ICC has not managed to convict any of the 6 so-called Ocampo 6 suspects in this case. What does this say about the ICC process in Kenya?
No, I think Ocampo just made the biggest mistake by saying that by giving this thing a political angle and saying he's going to prosecute some from PNU and some from ODM. That by itself, I think, narrowed his scope of investigations. The truth of the matter is there's very little investigation that he did. So for example, I'll give you a classic example. In the Ruto case, one witness gave live evidence talking about a meeting that was held in 64 Stadium and giving details of the podium where the deputy president and the then prime minister were supposed to have given their speech. Later on, only to be confronted with evidence showing that the meeting actually took place at Huruma grounds, and the words that were alleged to have been spoken by the deputy president were not in that tape. Due diligence by the prosecutor would have been much easier for him to go to media houses, because all these events were covered by media houses. He would have discovered that this meeting was not at 64 Stadium, it was at Huruma grounds, and that no such words were.
Right. Mr. Mwangi, final question, very quickly, in 30 seconds.
Yes.
Did this case become too politicized at some point?
All cases at the ICC are political, because usually the people who are alleged to have committed atrocities mostly were politicians. I would say the Kenyan situation was not as grave as the situation we had in northern Uganda, in DRC Congo, or in Central African Republic, or in Darfur region of the Sudan. It's not as grave as what has happened in the Gaza Strip, when the Israeli forces occupied the territory, right, or what has been happening in Syria. The double standard is what has made the African Union have great exception to the conduct of the prosecutor. But all in all, personally, I think this court, the intention to create the court was good. But when the big powers refused to sign into that, into the Treaty of Rome, then they had problems from day one.
Right.
Yes.
Thank you, sir.
You're welcome.
Njenga Mwangi, advocate of the higher court, was also licensed to practice at the ICC. Just putting some more perspective into the ruling earlier tonight by the ICC to terminate the case against Deputy President William Ruto and former radio journalist Joshua Arap Sang.